See.
My colleague, the University of Maryland onesie for her to put her new baby in a few months. So
Which one?
the terrapins, the red.
No, I know what the onesie is. Which color?
Lauren. I chose Lauren because I think she's in front of you more than Hannah, but now I'm regretting. I don't know if that was the right choice. Although I guess I could give it to both of them and have both of them share it. I don't think that's.
I don't know about sharing baby clothes. I will just say this. Give it to Lauren.
Okay. That was my
because if she's in front of me, I can make her bring the baby in with the Maryland onesie. Yeah, there we go. Except I'm mad at the terrapin right now.
Oh,
I just
not caught up. Rough weekend.
Just, I love them and I'm watching them. They're good. They're a good team, but they're young. So they just don't go the whole 60 and they make a lot of mistakes. And I just if you can cut all that.
They play this weekend?
I don't even know who they play.
Michigan plays Washington.
What'd you say?
Michigan plays Washington.
Michigan plays Washington. Maryland. I don't know who Maryland's playing.
I don't know. All I know is I do live close enough to sell parking to home games, and I've never done it because it takes a lot of time and effort to stand out there with your sign, but it's also money. So
Maryland plays UCLA this weekend.
Oh,
which is going to be a problem.
but is UCLA that good?
They beat Penn State.
I don't know how good they are, but they've definitely been handling business.
Yep, they've been doing things, and we should have beat Washington. We should have beaten Nebraska. And now we're going to play a hot UCLA team.
And that was a game that led the coach to being fired, right? Now the coach is fired from Penn State.
Yep.
Yes.
Right? And he got what, $56 million?
49, yeah.
$49 million.
Yeah. So after 40, does it really matter? I don't know.
That extra stuff.
Luckily, they have a really smart clause in his contract or his buyout that if he's required to look for a new job.
Oh.
And if he finds a job that pays, I think it's more than $8 million.
Oh, I didn't hear that.
They only have to pay the remainder, and that school will take up the rest of it.
Oh.
Yeah, smart contract clause.
Wow. I was going to say he's just set.
Yeah. You just need a dude with a gun to tell the prosecutor what to do. He's gonna waive.
Oh, he's gonna waive. Oh, even better. Okay. Yeah. Are you ready to go ahead on that then? Or are you ready to go ahead on that waiver?
Yes, Mr. Max Stewart could come out and waive.
Okay.
I'll just write it off while we're talking.
I'm done. Court does call the case of the people of the state of Michigan versus Max Stewart.
Assistant Public Defender Ben Denworth on behalf of Mr. Max Stewart, who is joining me at the podium now. Sir, would you state your name for the record, please?
Hezekiah Max Stewart.
And Your Honor, I do believe we have a deal for a waiver of exam in this case.
Okay.
In exchange for waiving his exam, the prosecution is offering to let my client plead guilty to counts 2, 3, and 4 at a future date in the circuit court. And at that time, or at the time of sentencing, count 1, the 10-year felony would be dismissed. Is that correct?
That's correct, Judge. He pleads to counts 2, 3, and 4 in the circuit court with dismiss count.
All right. So, but he's waiving his preliminary examination.
Yes.
Sir, is that correct?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
For the record, people also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, he's just signing the form now.
All right. While he's doing that, you waive formal reading. Your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 4 counts. Pre-trial in this matter will be set for
October 27th at 1:30 for judgment.
October 27th, 2025, 1:30 before Judge Hammoud. Bond will continue.
Thank you, Your Honor.
Thank you. What was Warren Green doing on his?
I think we're holding on that one.
You're gonna hold on Warren Green.
Yes.
Okay.
We'll grab a cord. HDMI cord.
Pardon?
Can I run down to our office and grab a HDMI cord?
Sure. An HDMI cord? Is that what you need?
Yes.
We've got.
There's one here, but I don't want to take it.
Where, are you gonna play something?
Yes.
Video? You can, cord can be moved, but you can also play it from the podium if you need to.
Okay.
So either way, if you want to go grab one, go ahead. Take a stroll. We'll be here. No, that's okay because I've got a case I can handle and then.
Okay.
All right. Or one that might handle me. Mr. Warren Green, we're holding on yours.
Yes, we are, Your Honor.
All right.
I think we should approach. Just discuss the poll.
I heard that. I said, no, they're not, I'm not talking to them. I'm not, no. With you two, it could get real bad. It could just get bad. I'm just coasting along during the day. And the things people were saying about you, you disappeared. No, I was defending you. I was, what? Oh, it was horrible. It was horrible, some of the things they were saying. Wasn't it bad? It was, it really was. Is this like an approach or we need to sit down and have the conversation?
I'm trying to avoid your chambers. I feel bad taking people's time up if it's,
What?
I feel bad taking time up if we can, but I'd be happy to oblige with whatever.
She's so demanding. She just has her way. I'll see them in chambers because they're going to yell at each other. They were both, I'm watching the two of you and you're over there with each other animated. And then can we approach? Going back and talk. I'll talk on that when everybody can remain seated. And when Warren Green and, well, I don't have anyone, never mind. I'll deal with that. Well, not yet so easy. Court does call the case of the people versus Jeffrey Sanders.
Good afternoon, Your Honor. Rita Hanna, Assistant Prosecuting Attorney. I'm behalf of the people.
And Laura Yagi, Assistant Public Defender on behalf of Mr. Sanders.
All right. And he's.
So, Your Honor,
go ahead.
was the date and time set for preliminary examination. Before we even got to that point, there was some conversation I had with defense counsel regarding proceeding with this case, and also information I received that there is a CPS investigation. That investigation is based on the reports that defendant has been living with, or at least at the very least staying with the victim in violation of his PPO as well as violation of his bond conditions. I informed counsel of that. I know we had a chambers conference regarding that matter. It was the people's position that we were going to ask for remand to keep him in custody until we could have a bond violation hearing and to adjourn the exam to follow. The victim was not present here this morning, although there was some back and forth about whether or not she was on her way. The victim had expressed great fears about showing up here today and what the defendant would do if he knew that she was going to testify. After our chambers conference, Your Honor, I came out to call the victim. There was some conversation about having the victim appear via Zoom. So Deputy Raymond Hall and I called the victim to have a conversation with her about the possibility of her doing that. During that conversation, towards the end of the conversation, she caught our attention as we were hanging up the phone and said the defendant had been texting her throughout this whole day, essentially, throughout this whole procedure, and that she wanted someone to go look for him because he had texted her that he was going to run. I then left the conference room right away. I informed Public Defender Yagi about what we had learned and was looking for the defendant. My understanding at that point from Ms. Yagi was that the defendant was going to go use the restroom. I came out in the hallway. That is what he claimed he was doing. I had Deputy Raymond Hall follow him based on what we had just learned. Next thing I know, I was back in the courtroom. I heard police stop. And when I went out in the hallway, the defendant was no longer there. And it was my understanding that he had taken off.
In my understanding with reports from security that he took off, it would be the southern emergency entrance out of this building headed in a southerly direction. Ms. Yagi, anything?
Your Honor, I don't think there is anything I need to add at this point.
Based upon that, and this is date and time set for preliminary examination, I'm going to issue a bench warrant for the defendant's failure to appear. There will be no bond. That warrant will issue immediately. I have also marked the file that this matter, initially anyway, it might ultimately be set before Judge Washington, but should be set before me when we get him, and we will.
Thank you.
All right. Thank you. And that was going to be a bad conference. Ready? No. Not letting that go. Court does. Can we get Mr. Burke out?
Yeah, can you please step out, Mr. Burke? Thank you.
Oh, you got the other paperwork because you're waiting for his signature.
That's correct.
Okay. Does call the case of the people versus Jamie Burke.
Alex Chavalowski for the people.
And Alex Warren Green on behalf of Mr. Burke. Mr. Burke, when you get up here, can you please state your name for the court?
Good afternoon, Your Honor. My name is Jamie Kaylee Burke.
All right.
This is the plea agreement. Can you sign here?
Okay. While he's signing that, my understanding of the plea agreement is that the defendant is going to be pleading no contest to the charge of second degree. On his plea to that charge, count one would be dismissed. There is also, once I get the form, some agreements that.
That's agreement for 2 years probation and restitution agreed on at $1,242.
This is the advice of rights. And Your Honor, Mr. Burke is now signing the advice of rights form after I just provided the court the.
I can't actually be at that address for a year.
Okay. Write your address. Okay. That's fine.
Homes.
Yeah. I just.
Bad contact number as well.
Okay.
You can change that. Yeah. Appreciate that. And my copy is right here.
I have it here.
Thank you so much. And that's
Yes.
and
Yes.
with
Mr. Warren Green, that was a correct statement of the agreement.
It was, Your Honor. It's a full understanding.
Got it. That's all right. Well, may I have him sworn?
Right. You solemnly swear to affirm the testimony you're about to give, you the truth, the whole truth, and the truth, so help you God.
yes,
State your name, please.
Jamie Kaylee Burke.
All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and I will check the sentencing judge waiver of the form. But you will be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of retail fraud, second degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, that you'll not have a trial of any kind.
Correct, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Correct, Your Honor.
You understand you're giving up your right to appeal of right.
Correct, Your Honor.
Are you on probation or parole?
Jamie, at the time of the offense, you were, right?
Correct.
And you've been violated by Lenawee County for the arrest in this, right?
Correct.
Okay. So you were on probation. You're indicating they have taken sanctions for this?
They have, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
Okay, the court has been handed Ann Arbor Police Department report for their case number 23-57552. Any objection to the court having reviewed that report?
No. None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you from the time of me accepting your plea and the time of your sentence, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation to the court. The court would no longer be bound by that. You understand that?
I do, Your Honor.
And you understand also you would not be permitted to withdraw your plea.
Correct, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None that have not been stated on the record.
None from the defense, Your Honor.
All right, and has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 4th at 9 a.m.
set 4th,
Yes.
December 4th, 2025, 9 a.m. before Judge Valvo.
I'll do.
Bond in this case will continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Okay. That's all that I have, right?
Yes.
So there are people staring at me?
Yes.
Are we, oh, they were with that case. Gotcha. Okay. I don't, yeah, might want to find out. All right, this second.
Are these yours?
Veronica Webster.
Veronica Webster?
Webster. Webster.
I didn't have that.
No, but
Kind of case.
Oh, was it on my original document
Yeah.
this morning?
Yeah, it's long.
I'm double.
Okay, because of an emergency, I had to cancel my civil docket.
Oh.
And let me just double check. And so I handled the criminal docket that I just finished up, but
She was.
Thanks. Appreciate it.
All right. So the cases from today, they're here on a civil matter
They went to the 28th
at 9.
at 9 a.m. Yeah.
Okay, so we had to move those 2 weeks out. Sorry, folks.
You all day. How you been?
You've been here all day with me? How'd I do?
You did a great job.
Well, thank you. All right, you take care. We'll see you in a couple weeks.
48 at 9.
Yes, ma'am.
Ma'am, if you see the clerk's office, they can give you a notice to take with you.
Okay.
Do you think we should go forward?
I think he should be in custody.
No, I want to go on the record, yeah.
I know.
They found him, Your Honor, so I don't know.
Pardon?
if the court wanted to, I'm sorry, on Mr. Sanders, they found him, but they have him.
They have him?
They have him. Excellent police work. I don't know if the court.
Best in the state.
Do anything today?
Oh, yes. If you guys have time, let's bring him to me.
Your Honor, if I may, I'll go and pick him up right now. He's just around the corner.
Fantastic. I'll be here with bells on. All right, court is standing brief recess. I need that file back.
Get out of here. I will pull you in.
Well.
14A District Court for County of Washington, State of Michigan, not back to
You may be seated. Court does call case of the People versus Jeffrey Sanders.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Sanders, who is to my right.
Jeffrey Sanders.
All right.
Your Honor, before we start, I also just received a text message sent from the victim to the officer in charge, Deputy Hall. It's a screenshot at this stage. Of course, we need to get more information. It's a screenshot from someone named Jeffrey saying, you okay? If you want me in jail, just say so. She says, I don't want you to. That was read by him at 11:42 a.m. Then he says 9 out of 10 times I am. Then he says he back. Then he says, can you talk? Then he says, I'm gonna run. This seems to coincide with what the victim was telling us towards the end of our conversation.
Sorry. So I don't know where you want to start this, Yagi.
I frankly, I don't either. I think what I would request today is that this be set, reset for exam and set for bond violation hearing, because at this point today, I don't feel prepared to go forward on the bond violation aspect. To be candid with the court, I just need more time to talk to Mr. Sanders about these allegations that I just learned about a few hours ago, and I need to go through them in more depth and more detail with Mr. Sanders.
Okay, but just so that we're clear, as we were going through the conversation this morning regarding certain reports and certain other things and certain allegations by the alleged victim in this case, in a lot of ways is referencing his status right now. Aren't those irrelevant to the court? I mean, because, well, I won't say absolutely irrelevant, but for the purposes of today, certainly they're no longer relevant. I mean, even if, which was the court's attempt to try to determine as to whether or not he might pose some threat to the victim in this case, I don't even know that I need to go through that part of the analysis, because clearly he's demonstrated that he's a flight risk. And so he's not going anywhere today. I hope he enjoyed his little last half hour of freedom. And so, I mean, there's that issue. And also, we were getting indications, and they will get them, that he was texting the victim, and he's got a no comment. I mean, I'll set it for a hearing, but I don't know.
I think one of my questions, well, the first question would be, obviously, is there a bond violation? The next question is what is the appropriate sentence for that bond violation? One of the things that I do think is especially relevant is I do think it would be relevant for the court's consideration in terms of a sentence for a bond violation, the context of the conversations. And I don't have that at this time. And I think it would be important for me to be able to prepare and for the court to have, because, I don't want to necessarily go further today, but I think it does make a difference if there is contact with someone, versus if someone is calling, texting, and saying, will you respond? And then there's a response. I just think it matters in terms of sentence, even if it doesn't matter in terms of whether or not there's a violation, because one of the things that the state's witness said this morning was that she had been reaching out and asking for a response.
Your Honor, first of all, I'm sorry, may I?
Yes.
First of all, I don't appreciate that my conversation that I had with a victim in this case was overheard, listened to, whatever it may be. The part that's now being put on the record is also a great deal about why that victim did not show up today. And as we witnessed, quite frankly, she probably had good reason not to show today, because I don't know what defendant would have done. And I had to call this victim. I had to have deputies go out and have our victim advocate contact her and essentially tell her, take your kids and run, get out of the house, because that's very likely where he was going. After finding out that she was going to appear on Zoom. I mean, she was willing to appear on Zoom and testify today, despite all her hesitations, and he decides to run, and he's messaging. I cannot imagine a context where that is okay or acceptable or excusable in any way. We're here for a court hearing, and he is messaging her as we're talking to her. So I want to be very clear. I don't think it's appropriate to further put any statements the victim made on the record in front of this defendant, because quite frankly, we're just increasing her risk here. This is high lethality, 100%. And we're not going to contribute to making the risk for her even greater than it is by talking about statements she made incompetent speaking to me. We're just not going to do that. So I would ask Ms. Yagi to stop right there if she's going to get into further anything that has to do with what the statements the victim made.
I understand. I will request that it be set for bond violation hearing. I don't feel prepared today to address it. I think there are statements that are discoverable, and so I'll follow up with the prosecutor about that.
An effort to be made to have the victim available next week.
We'll do our best, Your Honor.
All right. So what I'm going to do is I'm going to, first of all, adjourn the preliminary examination. I'm going to keep the case. It would go back to Judge Washington on the 28th, but we'll get it heard sooner if I keep it. So I'll set the preliminary examination for October 21st, 2025, 9 a.m. That will be before me. Anything you want to say before I do what I'm going to do regarding bond?
Not from me, Your Honor.
Mr. Sanders, I'm just going to say this before I do it because I think it's important. Your attorney was back there, her and the prosecutor, going back and forth, and I'm sitting there listening. And I tried my best to make sure that every opportunity was at least afforded before any presumption was made regarding any contact, regarding any of that, by having the victim appear via Zoom. And you decide at some point that you are just going to not pay attention to any of these proceedings, do everything your own way. My understanding is you told an officer in the hallway that you weren't going to go anywhere, that you were going to the restroom, knowing darn well that you were just at some point trying to find your way out of this building. Also informed that at some point, which may lead to additional charges, when they're telling you to stop, you just kept going. And maybe you need to also understand this, that you set off in this building by going out an emergency exit, an incredible amount of protocols in this building to keep everybody here safe when you went out for your little half an hour jaunt where the heck you thought you were going, with the thought that you weren't going to get caught. If the court had made up its mind that I wasn't going to incarcerate you, you changed that. This is all you. Because as I've indicated, I have to be concerned about two things. One, at least before now, I wasn't concerned about you being a risk of flight, but I have to be concerned about that. And I have to be concerned also about the protection of the public, but particularly the victim in this case. My heart of hearts tells me that at some point, that's where you were headed, to terrorize her more, because you were gone. And because you left, had all kinds of court security down this way, trying to figure out what was going on. All kinds of debt. You threw law enforcement into this whole world of trying to find you. At the same time, trying to protect her and those 4 children, because there was no telling what she would do. So you might as well get used to one thing. You've shown me what you are at this point. I don't have to try to hear a whole lot from people about what you are, because I think you were going after her. And I'm going to tell you, on my watch, that's not going to happen. Defendant's previous bond is canceled. Defendant's bond is hereby ordered revoked. Defendant is remanded.
Yeah.
That it? 14A stands adjourned.
Chaos erupts in court as a defendant flees mid-hearing, sparking panic in a manhunt through the courthouse. When captured, the judge's tone turns cold but resolute, condemning recklessness and protecting the victim. "You showed me who you are," he says. Justice, order, and accountability crash back into focus.